Hi there, this is Erica Merrill, and I'm the founder of Perfect Legal Video. And I am very excited to have with us, as always, Attorney Nicole Reeves Lavallee. She is an amazing family attorney. She has her own firm out in the Worcester area. And today she's going to tell us about stipulations, which it sounds like something easy, but apparently people make it complicated. Nicole, welcome to the show. And what is a stipulation?
Thanks for having me. A stipulation is basically a judgment or a court order that you're going to be entering into. So, plaintiff and defendant, or if there's other defendants, everybody involved in the caption is going to be signing a stipulation saying, this is what we agree to. It could be part of an agreement, it could be a full agreement. You could be leaving certain things up to the judge. So it really kind of depends on what you want to do. But whatever that document is going to later become a court order.
Once it's a court order, that's pretty serious. It sounds like. What is the legal significance of the stipulation?
Well, that's exactly it. It is going to become a court order, and people need to understand that. You are signing a legally binding contract. Let me be clear about what a stipulation is. It's a legally binding contract. You're putting your name to it. The judge is looking at it. The judge is blessing it. And the judge has now made it a court order, which means you now have to follow that court order. So whatever it says you need to do is what you need to do. And if you don't, then you could be held in contempt or you could be held in breach of that contract. So there are severe ramifications for just randomly doing what you want and ignoring that stipulation that later became a court order.
Wow. And there's just usually so much coming at you in these legal situations that you may not even realize that this is a legally binding stipulation. So another issue is, as complicated as it is, what if English is not your first language? What do you do then?
Well, the reality is if you're doing it through the court system, you're entitled to an interpreter. So I'm suggesting that if your attorney hasn't already done so, or if you're in court without an attorney, you want to make sure that you let the court know that English is not my first language and an interpreter should be there. The great thing is a lot of the interpreters right now are still doing it by Zoom. So even if we don't have somebody in the courthouse because nobody requested it, it doesn't mean we can't wait a couple hours and get somebody on Zoom so that they can go over it with you. But the reality is this is a document. You are going to be held to the same standards even if you don't understand it. So you want to have an interpreter there to read the document over for you, or to have your attorney summarize it so that the translator can then tell you exactly what it says so that you know what you're entering into.
Well, that's good to know. I mean, I wouldn't even have thought of that. Get the interpreter in on Zoom. That's great advice. Can you tell us, is there anything else we should know before signing a stipulation?
Well, the first thing I'm going to tell you is read it. I know it sounds really crazy to do something like that, but really, I mean, sit down and read it. Yes, your attorney's read it. Maybe your attorney's even drafted it up. It doesn't mean that the attorney's perfect. There could be typos in there. It could be something that just says mother versus father. And great, that's a huge difference, isn't it? So you really want to read that document. You really want to know who you are because sometimes we use plaintiff and defendant. If the caption's wrong or if it's wrong listed in there, then guess what? There may be ramifications. So really you want to make sure that it's either using your name or some pronoun or that everything matches up. Because that's the easiest thing for people to just kind of flip flop and nobody realize it because we as attorneys drafting it up are writing it as we think we're saying it, but it doesn't mean it's always written on paper right. The other thing is know what you're actually signing. Simple things such as may or shall, they have huge meanings that can be interpreted different ways. So again, you've got to know that. You've got to know what your expectations are. You've got to understand exactly what you're signing and what the ramifications of not doing it are. So that's where, again, you're going to look at something, especially if English isn't your first language. You need to know that. You need to be able to go, wait a minute, I don't understand it. Let the attorney dummy down for you. Simple fact of the matter is, we talk like this all the time. We forget that you're a layperson. And it just happens because we're going about a million things and we're doing our thing and we know what it says. So we just assume sometimes that you know. And, stop us and go, I have no idea what this means, Nicole. Tell us. Because unfortunately, you're just shaking your head and nodding and going, yeah, great. I'm assuming you're no. I assume that what I'm telling you makes sense to you. If it doesn't, you need to articulate that to us. So don't be afraid to ask. And if it's somebody that's in, a housing specialist or a probation officer or some third party that's drafting it up, ask them. You don't want to ask the opposing party because they're not going to necessarily tell you the truth, but at least somebody that's on your side or a neutral party is going to be able to explain it. And if they can't explain in layman's terms that you can understand, then that tells me that's probably not the best thing for you to be signing.
That makes sense. So this next question kind of reminds me of when people are trying to get a bill passed and then they add all these things that you don't want to the thing that you do want. What if you do not like the stipulation and you don't agree with it?
Then don't sign it. That's the bottom line. Don't sign it. Until you put your name on that piece of paper and until it becomes a court order, you're not bound to it. Now, granted, there's times where I'm going to go, really, I'm sorry, Erica, but you really should sign this. This is in your best interest. And you're going to tell me, but Nicole, and I'm going to tell you all the pros and cons, but my job as an attorney is to educate you. And so I'm going to educate you and go, well, Erica, if we don't do this, this is what's going to end up happening, or this is what you can lose. So your job is to know what potential pitfalls are. So again, it's not going to be, oh, this is great. I don't really like it. Can I live with it? That's the question. Can I live with it? And is it the best thing that I can possibly do in this circumstance? And sometimes we have to live with that. Sometimes it's just a really bad deal because you walked in there unrepresented and the other attorney's writing all these words down. And guess what? We're doing it to look out for our client. I can tell you how many times I've written that up and I've done it all geared to my client. And then sometimes the probation officer reads and goes, so this is what you wanted to do. And the other party goes, no, that's not really. Oh, well, guess what? If you don't ask those questions, you don't know because the other attorney is working for the other side. So really, again, kind of know that information, ask the relevant questions, and then make a determination as to whether or not you really can sign it or if it's something you're going to go, nope, we're just going to have to let the judge decide. Because at the end of the day, that's your right to let the judge decide.
Can you just give us an example of a stipulation just in case the folks out there don't quite know what we're talking about?
Sure. So let's just say you're going in on a divorce. One of the things that we're going to address on a divorce, and we have children, is we're going to talk about who has physical custody, who has legal custody, and who's going to pay child support and what the parenting schedule will look like. So I would say the parties share joint legal custody. That's number one. Number two, it's going to say the mother shall have physical custody of the minor children. Number three, the father shall pay child support in the amount of $200 per week, payable through the Department of Revenue. Number four, the father shall have the following parenting schedule: every other weekend from Friday at 5 to Sunday at 5, and a Wednesday visit from 6 to 8. And then there's going to be caption on the top, and then there's going to be language on the bottom that says, I've read this agreement, I signed it freely and voluntarily, and I believe it to be fair and reasonable. And then you're going to have your signatures. Now, obviously, that's a very basic stipulation, and it could be everything, anything. It can be we're going to claim the taxes. It could be we're selling the house. It could be anything. So whatever pertains to your particular case is what the stipulation is going to include. But that's a general stipulation in a divorce. The first time you're going to go in, those are the kind of things that you're going to address. And then you're going to have your signatures lines, and then you're going to sign it.
Okay, so that makes sense. I mean, so a stipulation is just like the agreement. It's not like what I was thinking it was you can have this, but only if you do that. Like you can have your money for college, but only if you go to college.
Well, that could be a stipulation too. So if we have somebody of college age, we could say something that the parties are going to split the cost of UMass Amherst tuition rates up to 1/3 each, meaning the child's paying 1/3. And we're going to include things such as books, tuition, room and board, food, whatever we may include. So there are things that we can do for that. But yes, a stipulation is literally anything that you are presenting to the judge, again, whether it be a partial stipulation on some of the issues or all of the issues. But that's really what it's going to look at, is whatever we're talking about, whatever brings you to the court is going to be, hey, this is what we agree to.
So the $1,000,000 question is, what happens if you agree to something and later on you figure out that it's not a great situation for you and you'd like it to be changed?
Well, that all depends. We got to look at it. Is it a temporary order? Is it a judgment? Is it something that we can modify? So there's a lot of questions there that I, as attorney, going to go, let me see the document. Let me see what the court order is that's attached to it. And let's see if I can help you. Because some of the answers are, I'm sorry, you signed a bad deal. I can't help you. Next time, hire me. And it's unfortunately, that can be all I can do in some cases. Other cases, it's absolutely modifiable. Let's just say, for example, you worked out a parenting schedule with your ex and it's not working. It's just the child's flip-flopping back and forth and she's like a bouncing ball and you just want to kill yourself and your daughter is not doing well and it's just not a good situation. Okay, so maybe we need to look at that. So maybe we do a week on, week off if it's a joint custody situation where we're not doing this every other day thing. Maybe we look at a longer blocks of time, a 5-day period versus a 2-day for a week. So there's things that we can tweak. But again, you also have to prove a reason to go back into court. So you just saying, I don't like it, and I signed it a week ago, I'm going to go, sorry, you made a bad deal. You'll have to live with it. When there's a substantial material change in circumstances, come see me. Well, how do I get that, Nicole? Well, you're going to have to document everything that you possibly can. And then let's regroup and look at what you came up with in 6 months. And it might be 6 months. It might be 2 years. It might be 5 years later. So you may be bound by that document or you may be able to tweak it. So bad deals can be really bad deals for a really long time, or they can be forever, or they could be a short period of time because, I signed the agreement a month ago and my job just closed up. All the people got laid off. The business shut down. And I was in such a niche industry that, the next job available is 3,000 miles away. Okay, that's probably a legit reason to come into court immediately upon the entry of a judgment. But that doesn't happen that often.
So are you able to void a stipulation altogether?
Probably not. You really have to show that there was something that happened. There was fraud, there was duress, there was something that you didn't know about when you signed the agreement. So prime example is, let's say, for instance, you signed a separation agreement. Well, you're probably not going to get it voided out if, by the way, you just find out 6 months later or 2 years down the road that your husband had a retirement account. Well, that's not a reason to void it. It might be a reason to amend it and to get a judgment on that one particular item. But to void it out, you really have to show really fraud, coercion, duress, that you didn't know what you're signing. So again, maybe if you said, hey, I signed that, but English isn't my first language and I have no idea how to read it, and I brought it home and my sister read it to me in Portuguese, and all of a sudden it says something completely different than what I did. Maybe, but again, that's a maybe. It's not an automatic. So again, you really want to make sure that you have that attorney beforehand, because while we might be able to do a motion to vacate or a motion for reconsideration or other standing orders to get this overturned, we might not be able to. So many times we filed that motion for relief or motion to vacate and it's been denied. So you don't know what you're getting into after the fact, and you may be stuck with the rules there.
Well, I mean, that's really good to know, because it means that you're not always bound to what happens when you first get your agreements done. And so all hope isn't lost. And like you've said a million times, like, take notes, write everything down right when it happens, because you want to be able to point it out, save your texts. We've talked in the past about texts. I mean, there are some people that don't even talk to their exes on the phone, so that they do get everything in writing during communication. And then there are all those apps that we talked about in the past. I don't know if you want to touch on any of that before we go.
I think, again, it goes back to document, document, document. Absolutely. Those are all important things. And again, there might not be something I can do for you today, but what I'm going to tell you is, if I can't, this is going to be your saving grace. This is going to be the thing that makes or breaks it. Just had a client come in, and I asked her, and I said, well, where is your ex coming up with this information? She goes, I have no clue. So she wasn't able to articulate anything that he had listed in his modification as being truthful. And I go, okay, well, do we have documents to support that? And when she starts pulling out documents to say, this is our communication, this is what happened, and I'm looking at the document that he wrote, and I'm looking at the document she gave me, and I'm just kind of scratching my head going, I have no clue where he's coming up with that. So sometimes it's that our clients are actually telling us the truth and they have the supported documentation. That's going to be your saving grace, because guess what? He's going to go into court and he's going to look like a liar. So again, watch what you say. You know, it's always one thing that everyone tries to be. I know that they push your buttons. I know that. Believe me, I know that. But you take a step back, breathe. Would you be saying this if it was your boss? And if the answer is yes, then either one, you don't have a job, or you don't want a job, or two, it's appropriate. So again, take a step back, look at it from an objective perspective. Have somebody else look at it as an objective perspective before you send it out, because those are the things that are going to make or break something. And again, save it all and print it all. Don't save it in your phone. Don't tell me it's on the cloud. Don't tell me it's in a text message that's going to be deleted. Like, you guys have no idea how much all this stuff gets deleted. So print it out, please.
Really good advice. I want to thank you so much for joining us again today with this great information. You're probably saving people out there thousands of dollars, hundreds of thousands of dollars in some cases. But yeah, everybody out there that's listening, if you have a family matter that you would like some advice on and some help with in court, you absolutely call Attorney Nicole Reeves Lavallee and her team. They are amazing at what they do. They've got the strategies, they've got the experience. They do this every single day. And believe me, if you're not an attorney, and even if you are a family attorney, you're not going to want, you're too emotional to do this yourself. You need outside eyes, you need a voice of reason, and someone that can really help get you through that when the times are tough in the court. So we will see you all later. Thank you so much for joining us. And thanks again, Nicole. I hope you have a great weekend.
Thank you. You too.
Absolutely. And thanks everyone for watching. Bye-bye now.